Here we are in Ways and Means. It's still Wednesday at 10:35. We are swapping our agenda around a little bit. We're going to do H 657 before we do H 937 because the Senate has inconveniently scheduled their floor time. So apologies. You should not, certainly not you, Katie. Thank you for being here, and I'd love to hear about the bill.
You're welcome. Katie McLean, Office of Legislative Counsel. Let me share my screen. Okay. So this is H 657. We've been referring to it as a miscellaneous DCF bill, or a DCF omnibus bill, I shouldn't say miscellaneous. But there are elements in this bill related to Reach Up, children's Social Security benefits, creating a path for unaccompanied youth to access different services without parental consent. There are provisions about transporting a child that is in DCF custody and what that transport should look like. There are provisions about seclusion and restraint protocols for children in DCF custody. There is a working group, I forget the title at this point, but in response to the DCF pregnancy calendar and working with different entities to create a path forward. So those are sort of the many elements. And I guess I'll just jump in.
And like we can do pretty high level on most of the sections.
Okay. John Gray, I think, is still scheduled. No. And he drafted sections 2 and 3 of the bill, so I will happily let him describe those to you. Section 1 of the bill pertains to Reach Up. Currently, Reach Up has a $9,000 asset limit with exceptions for IRAs, 401k, and VHIP accounts. So this proposal is to remove the asset limit so that families participating in Reach Up could continue to build their assets potentially for a down payment or on a house or a security deposit on an apartment, whatever. But the concept behind this is to allow low-income families receiving Reach Up to be able to develop their assets. And then there's just an affirmative sentence that says the department shall not impose an asset limit for the purpose of initial and continuing eligibility for the Reach Up program. So it's not just that it's being struck through and leaving the decision up to the department. There's affirmative statement. Sections 2 and 3 are Social Security benefits for youth and foster care. So those are the 2 sections that I will skip over for now and leave to Don. Next, we have a series of sections that are specific to unaccompanied youth. This first section really sort of lays out the concept, and then the remaining sections are kind of corresponding sections. So oops, I have so many pop-ups from emails right now, I'm sorry. So homeless children and youth means individuals who lack a fixed, regular, and adequate nighttime residence, including children and youth, sharing the housing of other persons due to loss of housing, economic hardship, and similar reason. Children and youth living in motels, hotels, trailer parks, or camping grounds due to lack of alternative adequate accommodations. Children and youth living in emergency or transitional shelters. Children and youth abandoned in hospitals. Children and youth living in a primary nighttime residence that is a public or private place not designed for ordinarily for regular sleeping accommodation for human beings. Children and youth living in cars, parks, public spaces, abandoned.
You don't need to read it.
Okay, I'm sorry.
Okay.
I wanted you to have a sense of who we're talking about. Okay. So needless to say, children who are not accompanied by a parent or guardian. So this section allows for an unaccompanied youth to obtain a certificate, and that certificate can be used to obtain different services without parental consent. So they can get this certificate if they're found by a school district, homeless liaison, or another appropriate person to be an unaccompanied youth, or that they're believed to be an unaccompanied youth by the director of an emergency shelter program, the director of a runaway homeless youth program, continuum of care, lead agency, chief justice, chief juvenile defender designee, Vermont Network Against Domestic or Sexual Violence. So those are all the entities that could provide this certification. And then with the proof of certification, Elevate Youth Services, Vermont Coalition of Runaway Homeless Services is to develop a standardized form that should be used for this purpose. The front of the form includes all the circumstances the youth can use the form for, the date the youth was certified, confirmation from the certifying individual that they've completed a human trafficking training, etc. This section of statute is reproduced on the back of the form, so that when the youth is using the form, the person receiving it has some reference of what this form is and why they're receiving it. Okay. Subdivision 2 lists all the services or benefits that the youth could obtain without parental consent.
And Ways and Means, this is the reason why we have this bill.
Okay. So they could apply at no charge for a non-driver identification card, a learner's permit or an operator's license or an operator's privilege card. They could obtain a vital event certificate at no charge. Top of page 8. They can consent to care by a healthcare professional licensed or certified in Vermont. Don't think that's probably the provision you're most interested in. They could enter into a contract for housing or obtain admission to a shelter or transitional housing. They could obtain employment pursuant to the provisions in current law. Purchase an automobile or obtain an automobile liability policy that meets the requirements in Title 23. They could apply for a student loan, obtain admission to high school or post-secondary school, and participate in school activities, including extracurricular activities and field trips. Open an account of a state or federally chartered bank or credit union, and receive services for victims of domestic or sexual violence as appropriate.
I heard you say they can buy a car and then get insurance for the car and rent an apartment. Can they get other insurance policies like life insurance and insurance for personal property in there?
That's not discussed in this section, so no. There's nothing in this language that specifically authorizes that they could get that type of insurance. This language is limited to the car insurance.
Well,
So if that is a change that you're interested in making, I recommend you talk to the Human Services Committee about an amendment.
talk to the committee about it.
But that is out, so it's not this, so there are places where they're able to obtain a license without a fee, and that is sort of where our very limited jurisdiction over this bill is. It's a really, really important issue, and I've worked with a lot of youth who had absolutely no way of getting consent or even contact from adults in their lives, parents. And I think this is like a huge, wonderful, beautiful step forward for children. I just don't want to mess with the bill without the Human Services Committee because they might have made that decision very strategically. I don't know.
Okay.
And it's outside of our zone. Yes.
Katie, maybe you mentioned this initially, but again, when you're talking youth, what's the age now that we're talking about to be able to receive all these?
Did we define that? We just say an individual. We don't define an age. We just say children or youth.
I guess
Does it
I'm
say
confused.
did I miss?
I don't see how, if there's not an age requirement, I don't see how you can allow them to get a license or, apply for dental and medical health care. I would. And again, I haven't had the time to look this all over either, but again, if it's a youth under the age of 18, I would think still there would have to be some agency individual or something that would help them through any of these requirements that you've just laid out here.
So Katie, can you help me understand sort of deeper in DCF law? At some age, an unaccompanied child would be assigned a foster parent who would have these legal rights. And then at some point that sort of stopped happening, and that's mostly the zone of youth for the age range of youth we're talking about.
Yeah, I'm hesitant to specifically answer the question with an age range
Yeah.
because I just don't feel like I have that at my fingertips, but there were conversations of like late teens, 18, 19, 20, taking advantage of this, but there is not an age range specific to this section that I'm seeing.
I think the younger youth that you're thinking about, those would be in state's custody, and the foster parent would have sort of these legal abilities. It's that there's an age when you tend to not be put in foster care anymore and also don't necessarily have these legal recourses.
But again, specifically, I don't see that in here where it talks about those age groups have to be within state custody or, you know.
I think that's other places in statute where maybe we could learn more about.
I can ask some clarifying questions.
Things.
Representative Maslin.
Good. Member Higley's question is essentially good, but the list of things in the bill are all worthwhile things that I would like to avail ourselves in the legislature to. So thank you.
Yes.
I think section 5 on page 11. I don't know if that is a controlling age for youths.
Well, can you give me a line number, please?
8.
First, the cost. The cost, it's only about cost of copies from the game.
Just don't know.
No, so this is specific to vital event certificates, so it wouldn't be controlling on the section that we're looking at.
Does anyone else have any questions on section 4? Representative Fulton.
My understanding is, don't we have separate statute around the legal age of emancipation being 18? And so that, I think you're talking, there's a lot of that stuff you actually can't get till you're 21. So my guess is that this is the gap, as the chair was saying, between.
Let's find out. Yeah.
I will get you an answer.
Thank you.
Section 5, okay, so all of the following sections relate back to this unaccompanied youth provision. These are corresponding changes that were necessary to make in specific statutes to allow the unaccompanied youth with the certificate to obtain a service under those sections. So first is the vital event certificates. And this subsection B says that the state registrar shall waive a fee for certified copies of a vital event certificates issued to, and then we're adding to the list unaccompanied youth with the certificate. Similar idea in the section 6 non-driver identification card. The lead-in language, where are we? That the commissioner shall require payment of a $29 fee at the time of application for an identification card, except that an initial non-driver identification card shall be issued at no charge to an unaccompanied youth who has obtained a certificate. License and privilege cards, similar concept. Page 14, unaccompanied youth who has obtained a certificate shall be provided with an operator's license or privilege card at no fee. No additional fee shall be due for a motorcycle endorsement for an unaccompanied youth. Section 8 is the learner's permit. There is an exception of no fee charged for unaccompanied youth who has obtained a certificate. The fee there is $24. Let's see, page 15, the fee for the examination is $11. That's the learner's permit, no fee for the youth with the certificate. Motorcycle learner's permit, and unaccompanied youth who has obtained a certificate. And an existing law, individual under 23 years of age in the care and custody of DCF. After attaining 14 years of age, shall not be charged a fee for the renewal of a motorcycle learner's permit. Page 16, D2. This is a $24 fee to the commissioner for each learner's permit or a duplicate or renewal. And this waives the fee for the unaccompanied youth with the certificate. So those are all the fee sections related to unaccompanied youth. Do you want me to go through? Okay. There is a section on the transportation of children in terms of what is meant by secure transport and different types of restraint for transport. So we have some modified existing language. We have some language about contracts for transportation have to meet the requirements or include the requirements of this section. Transportation with non-contracted law enforcement shall only be authorized in emergency situations or by court order. This requires the commissioner to provide educational materials complying with this section that outline the legal requirements for secure transport. Secure transport shall only be used if the department determines it's necessary to prevent risk of harm. F, we have existing language and then language that soft mechanical restraints are the first option for restraint and other mechanical restraints are not utilized as a substitute if the soft restraints are deemed adequate. In G and it keep going. Okay. Talks about documentation, the use of waist shackles, supervisory review by the department, annual reporting on secure transports, annual report from the department on states attorneys and sheriffs. Section 10 is a report pertaining to restraint in the transportation of children, all policy and not fees. Section 11 is a use of force policy, asking the Vermont Criminal Justice Council to look at, to do a formal review to determine whether its use of force policy should include an appendix to adequately address the transportation by law enforcement of children under 18 that aligns with public policy considerations established in this bill. Changing topics slightly. Section 12 is a restraint and seclusion section that is separate and apart from transport-related restraint concerns. So we have definitions of what restraint, child means, prone restraint, seclusion, strip search, least restrictive, soft restraint, secure residential program. And then in B, there's this language that the department shall not use or authorize the use of prone restraints, mechanical restraints, chemical restraints, or strip searches on a child. There are some exceptions, but they are limited and towards the bottom of this section. Seclusion or physical restraint shall not be used for punishment or disciplinary purposes. This dictates that if a staff member shall use the less restrictive interventions unless the less restrictive would not stop an imminent danger. There is sort of a list of considerations that the staff member has to go through prior to using different types of restraints. There are some timelines for how long restraint seclusion should last and what the proper oversight and approval should be for going beyond those time limits. I don't know how detailed you want. There's some language about documentation, records. Okay. So I will just move through this. Section 13 amends a section we were just looking at a different time period. So it's tiered effective dates of the same section. Section 14 is a report on children in correctional facilities in terms of the use of seclusion and restraint. Means for reducing physical and psychological trauma.
Do we have a place where we're sending these children?
Much of what is contemplated here are residential placements when the child is in DCF custody, and there's a definition of a secure residential placement. So that those are sort of the settings that are being envisioned here.
We do occasionally have children in our regular prisons.
Okay. I mean, we used to have a facility and then we're looking for something new apparently. So I was just curious whether we have, you know, a plan for where these kids are going.
Representative Maslin.
Thank you, Madam Chair. I think it would be helpful, given the questions around the table, to have a brief update from the policy committee. A little bit more about this if we have time, and I think what's in the bill is fine. Good. But, there are a number of us here would like to know more than we do. Thank you.
Okay, so this is section 14 is the report. Section 15 is, I think likewise, a report, on extending, this is a written report in consultation with the judicial branch, about recommendations for court oversight processes that meet federal requirements to allow access to federal funds, to support certain youth. Section 16 is the working group I referenced initially. This is the prenatal engagement and family support working group. The working group examines DCF's current practice of using a pregnancy calendar to monitor and track certain pregnant individuals and provide recommendations to alternatives. You have a list of members, powers and duties of this group. A report is due by November of this year. Some language about setup and of the committee itself or the working group. Of interest to this committee is that an allowance for not more than 5 meetings with per diem and reimbursement expenses taken from DCF for those 5 meetings for individuals who are not participating in their professional capacity. And then we have the effective date section. So that is the end of the bill. I will get more information about ages for that section 4 and how would be the best way to communicate that to you, assuming I'm not gonna pop back in quickly and easily an email to you.
You can send it to me and Sorsha.
Okay,
If I visit Sorsha, will.
Okay, I will do that.
Thank you very much, Kitty.
You're welcome.
John, hi, perfect. Can you show us the sections of 657? Yeah.
Again,
All right.
Andre, Office of Benefit of Council. We'll screen share 2 sections of this bill with you. Good, okay. Social Security benefits for youth in foster care. Just for orientation, the problem that these sections are trying to solve is that currently the DCF for folks who are in foster care is designated in certain instances to be the representative payee for certain children that are receiving Social Security benefits. So both survivors benefits, retirement disability survivors benefits under Title II of the Social Security Act, and also supplemental security income. So when the department is representative payee, they have certain obligations as to how they can use that money. As I understand it, the current practice is that they dedicate those funds to reimbursing the costs of foster care. And what these sections would do is essentially mandate that the funds not be used in the first instance to reimburse for foster care, but to be either conserved for the child in a trust account or applied to certain unmet needs. So for instance, if the child was going to attend a particular class and that was in their best interest, the department would use the money for those purposes. So instead of diverting the funds to DCF reimbursement, they now are used exclusively for unmet needs or conserving for the child upon exit from foster care. So section 2 is amending an existing definition section to pick up a few core concepts for this. So one is qualified able account. These are tax advantage accounts that are available to folks with qualifying disabilities. This is the kind of trust account that would be used for a child receiving supplemental security income, and they get certain tax advantages from using that. That's why that's included here. We've just talked about representative pay. That's who the SSA appoints to manage the Social Security benefits for a child. And then I call out, the text calls out a few different kinds of benefits. So RSDI benefits, that's your classic Social Security benefits, Title II, retirement survivors disability insurance. You know what the Social Security Act is, but there's the citation. Social Security benefits would encompass both a child's RSDI and SSI benefits. And then your SSI benefits are that supplemental security income. That's under a different title of the Social Security Act. The actual provisions themselves are on page 4. In the first instance, under subsection A, DCF is prohibited from using any portion of a child's Social Security benefits to offset the state's costs for the child's maintenance, except as required to maintain their eligibility for SSI benefits and to avoid a violation of federal asset or resource limitations. So if you think about it, in switching to a new practice where you wouldn't be diverting, one effect might be that a trust account rises. And then if there are asset limitations, it would actually kick the child out of that benefit, right? Because they would have crossed the threshold for the resources. So this section is saying you can't use benefits to offset the state's costs, but if it's to their advantage, basically, if you can stop them from violating a federal asset limitation to preserve their receipt of those benefits, in that case, you can.
Thank you. Is there so the state's the trustee? Or who exactly is the trustee?
I will come to that in a little bit, but DCF in conjunction with the Treasurer's Department would be setting up the trust accounts. So the idea, I think, is that the Treasurer's Office would hold the trust accounts, but all of the administrative pieces would be dealt with through DCF. I think that's.
There'll be a trust document through this Treasurer's Department or something like that that outlines how it works.
Yep.
I don't mean to be micromanaging.
No, you're good. And you'll see when we come to the directives for DCF and the Treasurer's Department that there are things like annual reporting on use of funds and the like. Yep.
Thank you. Good.
Is there a federal requirement that DCF is the one who handles any of this?
There is no requirement that DCF be the representative payee, which is, I think, part of your question. There's kind of a priority list of would be appointed as a representative payee for a child. But if you think about what's on that list, it's, relatives, friends who are capable of providing that kind of care. If you're talking about a child that's in foster care, you may be far down the priority list, at which case DCF is serving as representative payee. And they do currently serve as representative payee for a number of children. So at that point, they do have the obligation to manage they are required to manage the child's benefits at that point.
I'm gonna,
I was just wondering,
Yes, sorry.
DCF versus the treasurer.
Oh,
Does this federal government say it has to be DCF versus the
it's
treasurer?
been DCF for a long time.
I don't think I care.
Okay.
it doesn't have to be DCF, but
They have
it's,
so much to do.
And I just want to offer again, this is outside of our committee's jurisdiction and we have
Right.
crossover week. And I have a great update for the committee, which is that Ann Donahue is the reporter on the bill. So everyone who has very good questions about a very interesting piece of state government and child protection can talk to Ann Donahue, please.
Thank you.
So, John, can the child access these funds, like, say, for an allowance?
I don't think it, in the instance where you have a representative payee, and this may be a bit beyond my expertise in this area, it is the representative payee's duty to manage in the best interests of the child. So conceivably, that could be within the representative payee's determination. But I think in this instance, what's being contemplated is that there's no reimbursement for standard care. It's only beyond the maintenance of the child's needs that the Social Security benefits are being used, and they're being applied to, for instance, unmet needs, which could be like going to particular classes, or I think the real target of the bill is to be conserved in account for those, in which case, if they're in the trust account, they're not accessible to the child. But in any instance, it's the representative payee's obligation. The reason that they're designated representative payee is that the child is deemed incapable as a child of managing the funds, right?
So, Madam Chair, John, my understanding is, so currently some of that money that comes into the foster care child is used for foster care costs.
That's exactly right.
Okay, so again, I think that's where we should come into play is how much is the state possibly going to lose in that regard, correct?
And we are going to hear from Nolan in 1 minute, though, that is actually more of sort of an appropriations decision than a revenue decision. It's basically like, how are we spending the money that's already coming in?
Thank you.
It's really just that tiny fee waiver thing why we're all so deeply curious about this genuinely very important area of statute and child protection.
Happy to talk less rather than more. Subsection B, this is saying that upon request of the child or their provider, the department as represented payee may use those benefits for unmet needs beyond that the state is obligated, required, or agrees to pay. Those you can think of the state as now being required to internalize those costs, but they could apply these social security benefits to those unmet needs that are not required obligations of the state. And that would be things like going to classes that the child requires to go to. Subsection C, these are the set of directives I was noting before in capacity as representative payee. And with the assistance of the treasurer, DCF shall establish a trust account for the child, which in the instance of the child who is receiving SSI benefits would be that qualified able account. Additionally, they would need to monitor federal asset or resource limitations to ensure that you don't breach those thresholds and deny the child access to those benefits. 3, you need to, DCF must ensure that the child's best interests are served by using those benefits for the child's unmet needs or conserving the child's benefits in a way that avoids violating those resource limitations that would affect the child's ability to receive the benefits. And then 4, appeal any denied application for SSI benefits submitted on behalf of the child. As you can imagine, some children don't come in currently under SSI, and so the department may apply on their behalf. This is saying the DCF would need to appeal any denied applications to ensure that you're maximizing the amount of benefits that children are receiving. And then lastly, this was the point noted earlier, provide an annual accounting of the use, application, or conservation of those benefits, including any payments made for unmet needs under subsection B. And that would go to the child, their parent, guardian, or counsel, the family division of the Superior Court, and the Office of the Child, Youth, and Family Advocate. It's the full of my sections trying to solve the problem that I set out at the start.
Any other questions for John? Thank you, John.
You guys?
Ellen, it's your turn.
I haven't had a chance to zoom in yet. I apologize. This will take longer than my testimony.
Do you want to not zoom in then?
No, I'm almost. It's not a testament to how long this takes, it's a testament to how short I'll be.
Yeah, it's even.
All right, in theory. That holds true. All right, for the record, Nolan Langwell, Joint Fiscal Office. Well, fiscal note. Okay. Right, again, for the record, Nolan Langwell, Joint Fiscal Office. I believe the reason that this is in your committee is because there are several sections that waive fees. My fiscal note flags sections 7 and 8, which is waives the motor vehicle and motorcycle license learners permits. It also, section 5 would waive the fees. Again, this is for the children that are, defined as unaccompanied. Section 5 is not on my fiscal note, but would waive the $10 fee for things such as vital records. And then I believe then there's another WIP fee that's waived on page 12, $29 for ID cards. Anyway, throughout the bill, there's several pieces. I didn't flag those that waive fees. So the point is that the fee waive for these would be very de minimis. I tried to do a back of the envelope of how many unaccompanied kids might be allowed to have their fees waived for their driver's license or for their learner's permits. And if the number is quite small, we're talking, maybe between $1,000 and $4,000 annually tops. And again, if that much. So I think that all these fee waivers, that's $39 for your learner's permit or $49, like $10 for some of these others. And the point is that fee waiving for this small, very small population would be very de minimis and no budget impact.
Can you tell us a little bit more about how the social security money?
I could talk about,
Terrible burden.
no. I'm not an expert on how SSI works, but the bill, I think John talked about this, would waive. So the way it works now is that the department uses, this is my understanding how it works. They use the money that's from SSI to cover the cost of care for those youth in custodies. And this bill would not allow the department to do that. So you'll see in the first page of section 3 on my fiscal note, the estimate would be about $700,000. So I say that because the department assumes that as I don't know if you would call it a revenue source, but they assume it as part of their costs for doing business. So by eliminating this section, there would then be a hole in their budget of $700,000 that they'd have to make up.
Did the committee discuss, or were you asked to calculate a higher asset test for region?
I was not asked, and I wasn't in the room for that part of the discussion.
I know it's $9,000 now. We have asset tests for different programs, whether it's down payment assistance programs, that kind of stuff. Just wondering, all right, so they didn't think about that, like
No.
50 grand or something.
No.
I continue to encourage everyone on the committee to talk to Ann Donahue about the many sections of the bill. Any other questions for Nolan? Thank you, Nolan.
Okay.
Your Zoom joining as well. Do folks want to have those conversations before we vote on the bill? Or are folks content with having those conversations after we vote? Because it's more about.
Get out before.
Okay.
Good.
Great, okay. We're gonna schedule in like 5 minutes for the vote. So if anyone thinks they're gonna need more than 5 minutes for the vote, please do let me and Sorcia know sooner rather
And
than
that
later.
could be this afternoon. Come on.
Yeah, maybe just right at 1 o'clock.
I won't be here.
Oh, well, perfect. Then you don't need to talk. I'm just kidding.
Might as well vote now.
I think we could do it there. I'm gonna think about that for 4 minutes.
Okay.
And we're gonna move on to whatever bill you're here for, Eric. 9:37. You're not even over there. You're over here. Thank you.
Right. One hand, you know. Present, this one? Yeah. That's okay. You.
Bye.
Thanks.
We'll see you soon, John.
Good morning, everybody. How are you?
Thanks for your patience with our shuffling.
Not at all. That time of year, it's very common. Eric Fitzpatrick with the Office of Legislative Counsel here to talk with the committee about H 937, I believe it is. Yes, which is the annual, pardon me. I like that way to put it. I fell off the Zoom. That's right. That's right. All right, and oops. That better? Not better. Thank you. So as this is the annual judiciary miscellaneous bill, it contains a wide variety of different discrete provisions related to a lot of different subjects in the judiciary arena. I think what this committee is interested in is probably pretty narrow. So my first question is, what is the committee's preference as far as what you'd like to hear about? Do you want me to just sort of focus in on?
I love a high level overview section by section and then really.
Train in on what
Yes.
more. Yep. So for purposes of the high level section by section, do you like to have the bill on the screen? Would that be helpful or just?
That's nice.
Yeah.
Everyone else think that's nice?
Yes.
Behind me, hopefully. All right. All right, so let's do a high level, and there's a lot here. So, and I, as the committee knows by now, when I'm going through a lot, tend to speak quick. So please feel free to jump in, slow me down. Ask me to be more clear. So, section 1, actually the first couple of sections deal with something that's currently in Vermont law. You see it, there's a lot of underlying language here, but it's not new. It's just being moved here from another location. All this language exists in another place in statute. It has to do with the profits of crime subchapter that currently is in the Center for Crime Victim, the Victims Compensation Board chapter. You may have heard of years ago, this is Vermont's version of what used to be known as the Son of Sam. And that's what this is. That's about prevents a criminal offender from being able to profit of their criminal behavior. And it provides the crime victim with a way, or the attorney general with a way to bring an action to recover those profits. Like let's say, for example, a person who was convicted of homicide then tries to write a book about the homicide and make money off it. It's sort of your stereotypical example. But all this does right now, this chapter is located in the Center for Crime, the Victims Compensation Board chapter. Both the Center for Crime Victim Services and the Attorney General agreed that doesn't really make sense. It should be over in the Attorney General's section of statute because they're the ones who enforce it. So you'll see at the very beginning there, that's where it's moved to, Chapter 7, Attorney General. So that's all this is relocating a bunch of statute from one place to another. That's section 1. That brings us to section 2, which has to do with the existing offense of a minor. And you'll see line 9, someone 12 years of age or older or under 21. And that 12-year minimum is important because that's how old someone has to be before someone can be charged with a juvenile offense. Someone younger than that cannot, but they could be subject to a child in need of supervision provision with DCF, but they can't be charged with a juvenile offense. So, but under current law, a person, either tries to show a fake ID or they're possessing alcohol when they shouldn't, a person who's underage. You have all these lists of offenses that they're not supposed to be doing right there. And the penalties is what this section refers to, because under the current law, they get referred to the diversion program and then the YSAP, which is the Youth Substance Awareness Safety Program. And right now, if they don't comply with the program like they're supposed to, they then get hit with the civil penalty as well as a license suspension. And under current law, there's an automatic reinstatement of their license after the period of suspension ends for one of these offenses, and that's E there, that's operating a motor vehicle when you have any amount of alcohol in your system, not just DUI, but anything 0.02 or above. It's anything above like confidence. But for some reason, that automatic reinstatement is not in the law for these other offenses that I was mentioning, using a false ID to buy alcohol, possessing cannabis in an amount of less than 1 ounce, consuming alcohol, those sorts of things. This was requested by the diversion program in the AG's office. They thought it was probably just an oversight that this automatic reinstatement language wasn't also in the provision for these offenses. And I'm sort of going into this piece in a little bit more detail because this is actually, I think, the piece that we'll circle back to it, but I think this is where your interest lies.
I do think it is, and I wonder if, Chris, you could tell me what the fiscal.
Reserve Joint Fiscal, my colleague Logan posted a very brief fiscal note, and I would say verbally that this is the reason why the bill came to House Ways and Means. And the reason is that with the automatic reinstatement of the suspended licenses, these individuals will no longer be required to pay a $96 reinstatement fee to DMV. That $96 reinstatement fee, goes into the transportation fund. Logan talked to DMV to see how many violations would fall under this. We expect this would be a really de minimis impact to the T fund of about $8,000 of foregone revenue. So that's in the context of a $320+ million. That's the fiscal impact.
Thanks, Chris. Any questions for Chris? Great, back to you, Aaron.
Thank you. So Section 3 of the bill, you'll see the 12 years of age or older. This has to do with a minor who's doing tobacco-related offenses. This was brought to us by the judiciary, who noticed that 12-year minimum threshold, which remember we just saw exists in these civil alcohol offenses, right there, line 9, existing law. For some reason, it was not a part of the civil tobacco offenses for people under age 21. And it should be, because as I mentioned, that's the minimum age for juvenile offenses. So that's just technically adding the 12 years of age or older piece, which is already in the alcohol statutes. That's that section. Does it again on line 15. Section 4, dissemination of electronic case records. This is a House bill that was the House Judiciary Committee took testimony on separately. There was unanimous consent. And basically what current law prohibits the court from allowing internet access to criminal case records. You'll see that's lines 1 and 2. This is dated probably 25 years ago. I believe it or not, I actually remember that when that was passed. It was I started working here. There was a very different perception, as you might imagine, about the internet and how certain records can't be put on the internet because it will just lead to people kind of trolling and that sort of thing. And so times have changed, and it has certainly. But now, as it happens, people can get these records at any time, and rather than make them go to the courthouse and look at them, their proposal is to just repeal that provision. But you see, they require the court, lines 9 and 10, to set forth some rules as to how it is that this public access would be provided. So that's that piece. The section 5. This has to do with the gist of it is, in a nutshell, generally speaking, the statute of limitations for an action to renew a judgment. So if you get a judgment in the civil division of Superior Courts, you have 8 years in which to renew it. Say the person doesn't pay, you want to bring in, I want to renew it. You got 8 years. There's a specific language here that has to do with specifically judgments in the family division that are related to family division action. So there's a specific procedure that's proposed for renewal of judgment statutes of limitations. So the 8-year limitation is going to be specific for the family division because the court and litigants in the family division came forward and said that 8-year length of time doesn't work. We need some specific rules. So that's what that's about in a nutshell. This purely technical section 6, you see line 17, we don't have district courts anymore since judicial restructuring in 2009 or so. So they're all superior courts. That's a technical change. Another technical change, section 7. This language exists elsewhere in statute about the foreclosure actions, appeals and foreclosure actions require court permission. When the mortgage foreclosure chapter was rewritten and relocated years ago, that's the same language was existed there, but we forgot, I mean, probably me, because I work at the bill, to repeal it here. So it's just a technical piece to make those two things consistent. Sections 8 and 9 are connected here. These both have to do with stalking. Stalking is both a criminal offense, and it can also be the subject of a civil order against stalking, like a relief from abuse order. A person could go to court, get an order. Stalking, generally, you'll see line 11, there's, in order to prove stalking, you have to show 2 or more acts over a period of time, however short. So evidently, there's been a couple of court decisions that construed that language to mean that the 2 acts had to occur on separate calendar days. So the proposal is to clarify that that's not the case. These 2 acts that constitute stalking don't have to be on separate calendar days, as long as they're 2 separate acts. And that's the exact same thing. Section 9, same change. You see line 12. Am I going too fast or not fast enough?
I think you're going at just the right speed. I need to go down to appropriations to report a bill. You all are welcome to vote on this without me. Thanks.
This is okay though?
Yeah.
All right. All right. Good.
The reporters from the youth bill are ideally going to be here at 11:45.
Okay. All right, at section 10, you see purely technical. It was an incorrect use of the word section, should be subchapter. Section, yes, so we caught those. Some of these things we catch in our office too over the summer. Hey, there's something I'll put in my folder for the miscellaneous bill. Law enforcement agency, right now, under current law, when there's an initial contact between the crime victim and an LEA, there's this list of information that the agency is supposed to provide the victim. And the Center for Crime Victim Services actually has a form that they provide to law enforcement agencies, and they use that form when they give it to victims. So the proposal was to add another piece of information that actually is already in that form that the law enforcement agency uses, and it's given to them by CCVS. So it's just basically conforming statute to practice because it's already in the form, and this is information about the victim's right to know if the defendant is at a correctional facility, where the defendant is, if they're released. And DOC has this offender locator website so that crime victims can use that to find out where their offender was. And they also can register for this automated notification system when the defendant is released. So this just provides the victim with information about how to find that stuff, basically. Section, as you see, this is just repealing. Remember, I mentioned how the profits from crime stuff was being moved from the compensation board to the AG. So here you see, we saw where it was reenacted, section 1. Here it's being repealed because it was being moved to that first section, which we saw. Speaking of the Victims' Compensation Board, this is a board that exists to award compensation to crime victims and their dependents to 5 members. You'll see right now at line 12, one of the members is a physician licensed to practice in the state, according to the board and the Center for Crime Victim Services. That's been found to be a little too restrictive, so they want to expand it a little bit. So any healthcare provider is licensed, could be a nurse practitioner or somebody of that nature, could also be the healthcare representative on the board. Section 14, again, you see line 4, just removing from the VCB their authority to deal with profits from crime because we moved that to the AG, remember? All right, this is something that House Prop was looking at this morning, another sort of number. I think it's of interest, but maybe not to the committee's jurisdiction necessarily, but Chris would know that better than I do. The story here is that a number of years ago, the restitution unit in the restitution department, what they do is they are able to provide crime victims with restitution when they suffer a loss as a result of a crime. And so they have this special fund. And not only do they provide, the court is required to order restitution in every one of these criminal cases, or at least state why they're not. So after the case, generally speaking, that's when they find out how much the restitution is, and the restitution unit has some lawyers and collection people. They can go after the offender, try and get it. They also have the ability, the unit, through this restitution special fund, to advance a crime victim some money. So before the conviction even happens, they can advance them some money if they can document that they've had some of these losses so that they have some money to kind of tide them over until the final conviction happens. A number of years back, that advance is capped. What it was capped for a number of years at $10,000. A number of years ago, the $10,000 cap was reduced to $5,000. But this is just purely technical. As I said, this was already done. But every place in statute where the 10 is supposed to be changed to 5, we missed a few. So that's what this is doing.
Excuse me,
Corresponding that.
Chris, does this have anything to do with the fiscal report?
Chris from Joint Fiscal, this has no fiscal impact. And this, as Eric said, this is literally just aligning existing statute to existing practice.
Thank you.
And you'll see a number of places where this change is made. So there's another one, page 18, line 6. Section 16, here's another example. These are all the notice of the profits of crime statutes being moved to the AG. Remember, they're repealed here because they were reenacted in section 1 of the bill. There's another one, section 17, moved to the Attorney General's office chapter. Another example of the 10,000 to 5,000, line 16 and 17 in the restitution chapter. Pre-trial risk assessments. This was requested by the court diversion program, and the proposal here is that under current law, generally speaking, the records of somebody who goes through the pretrial risk assessment program are kept confidential. And you see that right there. That's line 6 and 7 on that page. But then turning to page 22, then they're required to be kept. You see line 11 under current law for 3 years before they can be discarded. But the general length of time that records are kept under the public records law is actually 2 years. So they're just conforming that to the general 2-year length that records are retained under the public records law. This section 20 repeals all the statutes related to spendthrift guardianships, which is a quite old type of guardianship that is still on the books but is not used anymore. A guardianship is a person, I'll quote from the existing statute because it's actually interesting. The guardianship, a spendthrift guardianship is a guardianship of a person who, quote, who is liable to be put under guardianship on account of excessive drinking, gambling, idleness, or debauchery. So that statute is not used anymore, as you might guess. And so the probate judges, the Association of Probate Judges and Probate Rules Committee in the Supreme Court asked for this change. That we don't use this anymore. I should really just repeal the whole chapter. So that's what that is. This is the what is this one? Oh, right. There we go. So line 12, ever since, I don't know if anybody remembers what's known as the day is a day law that was passed. And one of the things is to try and no longer, when days are used in statute or court rule to refer to days, it counts every day and doesn't make exceptions for weekends and holidays and that sort of thing. And when the court did that, one of the things they did was they also switched to using multiples of 7 days. So anytime they refer to a court, something that has to be done within a certain period of time with respect to a court, they go to multiples of 7, but they missed one. So you see that line 12, that's going it's just from 15 to 14 with a multiple of 7. This also requested by the court, section 23, under the current law, these child custody determinations, when they're made, a certified copy of them has to be sent to the court administrator who has to file it as a foreign judgment. That is also outdated. Right now, the judgments are just put in the electronic filing system at the court. Everybody has access to it. So this is just old language that, they're not sending these things by certified mail anymore or certified copies. They're all just filed in the court's internal system. This is just a cross-reference. Both the court and the diversion program asked for this change. You see it's just an incorrect cross-reference, 2 of them, just, lines 5 and 6. Same thing, these are connected. The next section, exact same incorrect reference. This was a request from the Vermont Bar Association and the real property section of the bar. In the big picture, this one, you see a lot of heavy legalese in that section. The gist of that is that there was a Vermont Supreme Court decision in January named Hershon v. Abadoza Mills. The gist of that was that when property is transferred to 2 people who own it jointly together, that can happen. There's a number of different ways in which property can be owned jointly. And the Vermont Supreme Court had this decision where they said, well, if it's, we're going to interpret language in deeds and transfer documents to generally mean that the property is transferred in this one type of joint possession. It's called a tenancy in common. And that everybody in the Bar Association said that has never been interpreted that way. It's actually been interpreted to mean that when property is transferred to more than one person and it uses this particular language, it actually creates this other type of joint ownership known as a joint tenancy. So this corrects that and says, hey, if you use that language and you create this property interest as joint tenants with rights of survivorship, that means that, and that's a joint tenancy. That means that, say 2 people own property together and one person dies, then all the property goes to the other person. That's called the right of survivorship. Tenancy in common, let's say 2 people own property together, one person dies, the other person doesn't get it. It goes to that person's heirs. Could be their kids, could be maybe they wanted to leave their share in the property. Say 2 people own a camp together. I have to know that because my wife and her brother own this camp together. And they they own a tenancy in common. They don't want, when one person passes away, the other person to get it. They want that person's kids to be able to have their share. And you can do that however you want. It's up to you to decide how you want to do it. But the court had said, hey, when we see this language, we're going to interpret that to mean it's a tenancy in common, which means it has to go to your heirs as opposed to going to the other joint owner when one person dies. Bar Association seems to have unanimously agreed. That's not the way we read that language. So this goes back to the way they has been read. I'm not a property lawyer, so I don't know for sure, but everyone seemed to be unanimous in that respect. And section 27 is related to that. It's just saying that's basically applies retroactively. So whenever you created an estate, so say that transaction happened 3 years ago, because ordinarily laws only apply prospectively unless you say otherwise. So you see line 18, this says otherwise, notwithstanding 1 VSA section 214. That's the section of law that says laws generally apply prospectively going forward. Legislature can make an exception to that, but you have to be explicit about it. So that's what that does, makes an exception. Notwithstanding that, this applies retroactively whenever you created the deed, unless somebody has already started a lawsuit on it, and then whatever law is at that time applies. That one, section 28 is also a technical correction noticed by actually a member of the bar who pointed this out to me. Deeds aren't required to be sealed and witnessed anymore, so that language is struck. This is an interesting one.
Not required to be what anymore?
Sealed or witnessed.
Oh, thank you.
Yep, absolutely. This is a interesting, also old statute on the books. You see that anyone who finds money or goods value of $3 or more, or takes up a stray beast, the owner of which is not known, that within 6 days have to post notice in 2 public places in the town where the property was found. Evidently, this was brought to the attention of Representative Oliver by the Sergeant at Arms and Capitol Police, who are finding, like, every time we find a water bottle, we're thinking we have to post notice that we found a water bottle because it's more than $3 in value. So they decided to make it $50 and that way not cover small pieces of property that are left.
Covers about every new water bottle there.
I know, exactly. This is new. They're pricey. Yep.
And then section 30?
Section 30, let's see, what was that one? Oh, this is another example. You see line 4. This is the judiciary uses multiples of 7 now whenever referring to procedures that have to be done with respect to the court. So this has been done since the day is a day law a number of years ago, but we missed this one. So make it 14.
I have a kind of random question about that. The earlier one was 15 days, which I would have assumed was 3 weeks before, and it got lowered to 14 days.
Correct.
And that was a conscious choice to lower it to 14 to
Yes,
2
yeah.
weeks from 3 weeks.
But from 15 to 14 days, yeah.
But if it was 15 business days, you're lowering it 14 calendar days, you're lowering it from 3 weeks to 2 weeks, whereas this one is 10 days, that's becoming 14 days.
Interestingly, it's under the previous approach. If it was above 10 days, it was not business days, it was calendar days.
Okay.
So that 15 would have been, if it was 10 or, I know it's weird. That's why they decided, rather than try and keep track of all that, let's just do day as a day. Because the 10-day thing was the threshold. If it was above 10, it wasn't business day anymore, it was calendar. So it was only a 1-day difference to bump down to 14.
Thank you, Eric.
Yes.
Does anyone need to know anything else about this piece of legislation?
Just a comment.
Oh, great.
Thank you for establishing the uniformity that we.
Happy to help.
In France, a week is, they say every week is every 8 days, and every 2 weeks, every 15 days, it's just the way they speak there.
Oh.
But we're in the USA here, and I'm glad to have some uniformity that we agree to.
Right.
Any other thoughts or questions for Eric? Thank you, Eric.
Sure.
Does anyone need anything?
All good.
So, okay, to exit, you want, no more questions, right?
No, you may move on with your life. Thank you.
All right, thank you all. And any other questions do come up, just let me know.
Thank you.
Yep.
I would only want to ask JFO to again reiterate there is essentially no fiscal impacts.
Sure, Chris Root, joint fiscal, the only fiscal impact it is de minimis and it is, you know, in the order of $8,000 the T flash on those, for about $96 license and state fees in section 2. So it's a very, very tiny percentage of.
Hearing that, Madam Chair, I would move to find H 937 favorable.
I'll second.
Thank you. Representative Kimball moves that we find H 937 favorable. Representative Holcomb seconds. Any discussion? Being none, if the clerk can please call the roll.
Representative Brannigan is absent. I'll vote yes as Representative Burkhart. Representative Higley.
Yes.
Representative Holcomb.
Yes.
Representative Kimball.
Yes.
Representative Madlin. Representative Odie.
Yes.
Representative Page.
Yes.
Representative Wazazak.
Yes.
Representative Canfield.
Yes.
And Representative Kornheiser.
Yes.
We have voted the bill favorable, 10-0-1.
Thank you, everyone. Representative Page, you wanna?
If you'd like me
Thank you
to,
so much.
sure.
It's not gonna be in the next.
I don't think
2 days.
it'll be in the next 2 days then. Let's do an appropriation.
Appropriations heard it this morning. They
Oh.
were waiting, they were planning to vote later today.
Okay. No Representative Page on that one.
Okay.
Representative Odie. Can you report this?
Yes.
Thank you. And I noticed that Chris made a very clear differentiation between no impact and a de minimis impact. And I would like to remind the committee of those are two different things. Thank you. And we're going to take a brief pause in our recording while we